So the big issue today in claims for disability insurance benefits is that the Supreme Court of Canada has imposed upon the insurer or the insurance company a duty of fairness in assessing the claim and the way it regulates the claim through the claim process. And if the insurance company does not act fairly, then courts have awarded claims of aggravated damages, that is, damages for suffering, emotional suffering because of the unfairness, and also punitive damages. And the awards of punitive damages have been extraordinary. There was a case in Saskatchewan, which is not an extreme jurisdiction by any means, in which punitive damages were set at $500,000 against the disability insurer for basically screwing around the applicant in his case. And another case, well, it was another insurance company in the same case, $175,000 in punitive damages. Extraordinary. And awards of damages for mental distress, that is aggravated, are fairly common, $20,000 to $50,000 quite often, if the insurer does not act fairly in the claims process. But the big case, drum roll here please, is that there was a recent jury award made against Blue Cross for $1.5 million for punitive damages for not dealing with the insured's claim fairly and honestly. And that decision went to the Ontario Court of Appeal, which upheld the award, again, of $1.5 million. That's the highest punitive damage award in employment law, certainly, even though it was a straight disability claim, but semi-employment law. And it was a huge, huge shock to the legal community when that decision was upheld. So the end result is, if the insurer is jerking you around and not honoring the claim properly, you've got a good claim. Another word on this issue is that there's something called administrative services only. And that is a plan by which the employer assigns to an independent insurer the administration of the claim. That is, the insurer is not really an insurer, it's just a third party, determines if the claim is valid, and then the employer makes the payments. It's called administrative services only, ASO. The federal government has outlawed it. Ontario proposed to do so, but hasn't done it. But to make a long story even longer, if the employer is acting as an ASO, it is also responsible for the same aggravated damages and punitive damages itself. It'd be wise to join the third-party reviewer as well, but that's the case. And to make a long story even longer and longer, the whole details of the insurance regulation industry in Ontario and every other jurisdiction is to make sure the insurance companies are solvent and financially stable, so that when you have to make a claim, they're there, they're not going to go bankrupt. Yet, these jurisdictions have allowed the employer to effectively become the insurer without any detail of financial stability required. It's a joke. It never should be allowed. So if you see those initials, ASO, watch out. There's a famous case involving Northern Telecom which went bust, and all the employees on disability insurance, well, insurance is not the right word, on disability payments, they lost everything because of the bankruptcy of Northern Telecom. So it's not right.